September, visa bulletin, which was published on October 24th, in the morning hours is a very good news. And from 24th morning, 7 o'clock, we are continuously, talking to a lot of people, assisting them. And then, it's a great news for, a lot of people, those who are waiting in queue, for almost, 15, 16, 17 years. So, and usually how it works is, previously they used to have only one date in the visa bulletin. If it is current, they'll just go ahead and file the 485. But they changed it around, I guess 2015, saying that there is a final action date and then the filing dates. So if you fall into the final action dates, you really don't need any confirmation from anybody. Just go ahead and do it. But as per the filing dates, usually, USCIS confirms every time, coming back and then, saying, okay, which dates they just have to use it. So, Thursday whole day, there was no communication from the USCIS. Everybody was waiting on that. But by the end of the day, they came back and said it's only final action dates, but just within couple minutes or maybe 5-10 minutes, they just again, published another one saying that, the filing dates are the final one. So, which is a, huge movement towards, if we see the final action dates, for the EB2 category, the employment-based EB2 category, it's September 1st, 2009. But when we look into the EB3, it's January 15th, 2010. That is the final action dates. But when the USCIS announced at the end of the day that, they will consider the filing dates, the movement in there, at least, a couple of years for, EB2, which is May 15th, 2011, and then at least 5 years for EB3, which is January 1st, 2015. So when you look into, within this huge window of 5 years, a lot of opportunities for a lot of people. So those, who fall into these filing dates, definitely they can, obviously everybody knows, there's a big news for them. It's a celebration that, at least they can file the 485, along with the EAD and advanced parole. So still they have to wait in queue for their final green card years down the road. But at least the USCIS is giving, that kind of opportunity for them to go ahead and then, file the 485. So they'll have their EADs and advanced paroles. So they don't really have to, go back and forth on, the visas, the extensions and all those stuff. So that is a little bit background about, how the dates work and all. But this itself is not really sufficient, for the community, because when you look back, at least 10 years, everybody wants to get in line in the EB2 because all the spillovers happen to EB1, and then the remaining spill over to the EB2. By the time it comes to EB3, very less numbers. So everybody wants to get into EB2 category. I mean, in my experience, when I look into past 10 years, at least very few that I can count that, I mean, the requirements for the EB3, most of the applications are filed under EB2. So saying that, now EB3 dates are, at least, 5 years ahead of, EB2. Now everybody wants to downgrade their EB2 petition to EB3, which is, the requirements are, lesser. If one always meets the EB2 requirements, definitely they do, obviously meet the EB3 requirements. So the questions around here are, they are thinking on those lines, whether, is it a good idea to, downgrade from EB2 to EB3, and then when the dates are concurrently file. As per rules, yes, they definitely can, downgrade it based out of the EB2 perm and then refile the I-140 under the EB3 category. And as the dates will be current, what they should do is file the 485 and I-140 concurrently. So that way, at least, the application will go in the queue, and then, they will be, received and then, waiting on. So And around this, there are several other questions that we are facing past 2 days. Continuously people are consulting and asking, hey, if we are downgrading it, whether the EB2, petition that we still have there, will it have an impact? So, it shouldn't, the way how you do it, but you just have to check with your attorney and then make sure that they are refiling. It's not an amendment. They are refiling the downgrading and refiling the I-140, and also at the same time as the dates are current, they just have to go ahead concurrently with that. Saying that, the other major question here, because the guys are used to premium process all the time, so because at least they really want that peace of mind for them. If you do in the premium process, USCS offers for a price of 1440, they promise that they'll adjudicate the case within 15 calendar days. So usually, for H1Bs and then for some of the forms, the premium process is available. Yes, for I-140, the premium is available all the time. But in this scenario, when you are downgrading and then refiling, premium process is not available based on our experience, and then most of the time as per the rules, because when the employer filed your EB2 petition, the I-140, the original labor that was issued by the Department of Labor, which was valid, or which is valid for 6 months, have already been filed with the original I-140 in the EB2 category. So right now, if you want to downgrade, you just need to use a copy from the filing, whatever you filed under the EB2. So when you don't have the original, usually USCIS don't entertain the premium process, because as per their promise, they have to adjudicate within 15 calendar days, because they have to look out for that copy, and then they might not be able to honor that promise. So usually they don't honor the premium process on those lines, downgrading. But I would definitely encourage everybody, if you are qualified and if the employer is willing to, you can definitely downgrade it, and then file the I-140 and the 485 concurrently. So at least the I-140, 485, EAD, and then the advance parole will get receipted. But until the I-140 gets adjudicated under this new downgrade category, the EB3 category, your advanced paroles and EADs will be on hold. So bottom line, once you have your I-140 approval, then the 485 side of the file will move forward. So, that is one thing. And also, if we are hearing from a lot of clients, they are saying that, I guess during this start of the year, when, we hit the pandemic, in March and all, the uncertainty grew, especially in the job market. And then most of them kind of left their employers, with whom they have these, filings, the EB2 or EB3, and then try to take up full-time employments. And then now all of a sudden, 6 months, 7 months into it, when they see the news of, the 5 years forward movement, now they are trying to go back and then talk with the employer, tap on their door, and then say, hey, will you be willing to, um, you know for most of those kind of questions, our answer should be, our answer is, if the employer is willing to downgrade and still confirm that they still have that kind of job opportunity, whatever they offered for you on that permanent basis, the I-140, definitely you can go ahead. But a little bit challenging there would be, definitely the employer should show the ability to pay, how the initial petition went through the scrutiny of the ability to pay, and then the rest of the requirements, whether the beneficiary met or not. I guess from the beneficiary side, the applicant definitely meets the downgrade requirements, but major concern is whether the employer still be having that kind of ability to pay, because employee is no longer employed with them, and then they are not contributing to the corporation. So it all depends upon their financial status, and then given the pandemic, how it affected their business this year. One really has to keep all of these things in mind, and then at least we definitely encourage to approach your employers, requesting them, because this is kind of an opportunity that we are seeing after a very very long time, I think after 2007. uh, I mean, in 2013, of course, similar to us right now for the Indian nationals, the China's AB3 moved forward, forward pretty much in a similar scenario in 2013. And then that's when, they had that kind of mad rush, downgrading from EB2 to EB3 and then, filing concurrently. So the same thing is happening right now. And I would definitely say you have to have that clear talk with the employer. If you are no longer working with them, and if you are still working with them, make sure that whoever is doing the paperwork understands the pros and cons and how they are doing it, whether they are experienced in doing such cases previously, because this is a once in a lifetime kind of opportunity, because they opened up and moved forward. And then they also promised, like they kind of speculate for the coming months. So the projection in the bulletin also talks about, especially for China and India, EB2 and EB3, there will be a rapid forward movement. So we don't know how rapid forward movement it would be, whether it is months or years, but definitely keep an eye on that. um, those who are already eligible, I mean, everybody is trying to gather all the documentation, making appointments with the doctor's office for those medicals. And then people, those who don't have the affidavit, like birth certificates, they should get try to get the affidavits, or maybe try to go ahead and contact those the municipalities in India, getting in birth certificate. And then those who are still waiting, and then expecting in the coming months to be current, so I think it's a good opportunity to work on that, those kind of paperwork, so that way they will be well prepared. If it becomes current, you know what you are going to do, and then you'll be on top of it, providing all the required documents to the employer and the law office. So that way, yeah, most of the law firms, I guess, they are serving based on first in, first out kind of. So make sure that because they most likely will be working on so many cases, all of the law firms. So make sure you have all the documentation, and then move forward in that process. So saying this is a little bit background about. So and I think if we have any questions, then definitely I will be happy to answer those.
Sure. Thanks, Janetha. Thanks for everyone else joining, and we have few participants here. We'll open up the forum for questions, and please type away your questions in the channel wherever you're watching, and Ms. Janetha will be more than happy to answer your questions. Janetha, there's an interesting question, probably. I mean, not from the people, of course, who are participating. It's just a general observation. If an employee leaves ex-employer and the priority date is with the old employer's I-140 labor date, can he continue with the current employer to downgrade to EB3 using the old priority date and get it done, or he has to go back to the old employer and get it downgraded?
I mean, as long as, I mean, the whole green card process is the future employment. So as
Mhm.
long as the, previous employer still agrees to, downgrade it and then, move forward on those lines, he don't have to go back from the current job to the previous employer and then do that kind of work. But it all depends upon whether the employer is willing to, because as I said, ability to pay plays a very big role in here, because that's very crucial for your I-140. Because if I-140 falls apart, just based upon this simple scenario that an employer is not having the ability to pay, then your 485 also falls apart. So it's all based on the I-140 and then the ability to pay. And even USCIS might come back and ask, okay, show us whether the employer is having the ability to pay not only to this employer, like let's say the corporation has, let's say 10, 20, or 50 filings already in place. They will ask that, show us whether you do have the ability to pay along with this person, whoever you already have the I-140 approvals. They can always come back in the form of an RFE. That's why you really have to carefully have that kind of talk with the employer, specifically on those lines, especially on the ability to pay, and then see whether they will be willing to support you on those lines. If the employer says that having that kind of ability to pay, I would definitely advise them to go ahead. They don't have to move back to the employer. But I think when you look into the employer's perspective, I mean, they would be in much better positive situation if the employee comes back and works for them, because by working for them they are contributing I mean that kind of revenue to the corporation and then making that kind of money. So it helps them to show that ability to pay. But really, for your question, the answer would be they don't have to go as long as employer agrees to file.
Okay. In the same lines, maybe a redundancy is called for in this next question that I have for you, Janetha, is let's say I'm working for company B and my company B has filed 140 for me and it's approved. It's EB2, but my priority date came from my old employer's filing, labor. So with my current employer, company B, can I downgrade to EB3?
Yes, definitely. That's a good news for this guy, whoever posed the question, because right now you already have the priority date ported from your old filing to the current one. But of course, if it is in EB2 and then you are already working for this employer, I think, the opportunities are more for you to downgrade it to, from EB2 to EB3, refile the I-140 in EB3, and then also concurrently do the 485 along with the I-140 filing. So that way, as the visa bulletin is valid till end of the October, for the whole month of the October, so try to file in both together concurrently.
Oh, okay. So is there any chance that, I mean, we have seen quite often with USCIs to roll back the dates in next month's bulletin?
Yeah, they did that in 2015. They just kept it open for 3 days and moved it back. But as they are stating specifically, because it's a huge shift from the previous one, because they have the annual number all-time high. That's why these forward movement you can see. So I don't think so. They are going to go back at least till December, because the projection is for the couple of months. It's going to be a rapid forward movement. They said. So you don't know, but I guess they are not going to back. At least it will stay put on those lines at least for end of the year, I would say.
Oh,
But you never know.
and the advice here is to rush and do as fast as you can, as quickly as you can while it lasts, right?
Yes,
So,
yeah, the timely filing is very important in here.
yeah. There's a question from Uday Katakam. My date is current EB2 October 2010, but I changed jobs. My new employer just started on perm. What options do I have to file my I-485?
See, I mean, if the previous employer is willing to, then you can do that. But if they just file the labor, I guess you just need to wait and then put that priority date, and then at that point of time, because perm, I think it's taking around 5 to 6 months, but it always fluctuates. So if you are looking on those lines, you definitely are not sure whether these kind of dates are going to be available or not. So, I mean, I would say you have two options: one, going back and asking your previous employer, to downgrade it and do it on those lines, or just wait on your current employer, who already filed or willing to file the perm, just wait for the perm approval and then, file the I-140 in premium process. But if the old employer can support you, definitely that would be the best option for you. at least you will file it concurrently and have the 485 and the EAD's recepted EAD and advance parole.
Cool. Thanks. There's one more question from Venu Madhav. If I port to EB3 from EB2 and I get EAD, does my aging daughter good for future green card? I mean, like probably has an aging daughter, probably getting closer to being major, 18 plus, I believe. So is
Hmm.
she good to
Hmm.
go for future green card if she gets, if he files I-485 for the daughter as well?
Yes, she should be good, as long as she was added in the I-140 as a derivative beneficiary. And then, as per the CSPA, the age gets locked there when the I-140, at that point of time, the approval time. So she should be good to go, I mean, go ahead and file for her as well, the 485 and, EAD and advance parole as well.
Sure. Sure. There's one question from Anusha Reddy. Are the medicals mandatory now, or can they be provided at the time of fingerprints? My attorney insists that medicals are not required now. I don't know what state she is in, but is it mandatory while filing I-485?
See, previously they used to accept, and even some of the family based cases, they accept and then, do an RFE for not having the medicals in there. But as per, the new policies that the USCIS is doing these days, if they encash the checks for the 485 and then reject your petition for not having the medicals. So, I mean, I'm advising my clients definitely that is one piece of mandatory document that you need to get in, because I really don't want to take any risk on their petitions. So I would definitely advise you, to go ahead and schedule, the doctor's appointments. I think, they should be able to accommodate. So definitely, having the medicals, of course, down the line, you will get an RFE for, another medicals and all, but, make sure that the petition is not being just rejected for not having the, medicals. So my advice is, have the medicals done.
Cool. For everyone, get the medicals done up front and apply for I-485. So don't depend on the RFEs and that would come back and you can furnish them. So go ahead and do that, as Ms. Janetha mentioned. Janetha, moving on to the next question. Thank you very much. That's a very valid advice, actually, and it's a kind of a what do you call uh, the question or like a situation or incident that nobody comes up with basically is at what point it is good to have medicals. Thank you very much.
You're welcome.
Krishna Vamsi here's a question. He's applied his EB2 and apparently his university that he acquired masters from is not accredited, but his PD, I don't know what the full form of PD from Krishna Vamsi,
Priority date.
priority
Priority
date,
date.
sorry, is current
Hmm.
in both EB2 and EB3. What would be the best course of action for him, EB3 or EB2?
I mean, if you are qualified for EB2, definitely just look into those, in the labor copy, what are the requirements. If it says, of course, for EB2, at least it will be master's and master's plus experience, or it will be bachelor's plus 5 years. So if you are downgrading it to EB3, then, if you have a bachelor's, it should be a 4 year degree. I would definitely recommend that. A 4 year bachelor's degree and plus 2 to 3 years of experience would definitely cover you under the EB3. So make sure that look into the details of the form ETA 9089, and then make sure looking into the labor around the wages and the requirements for the position, and then see when you are downgrading it, you are meeting that EB3 requirements.
So, another question from Simple Life. And apparently, the handler name is Simple Life, and his question is not that simple. His or her question. Good luck to them. Uh, he's been laid off by his employer 2 months ago, but his date is current. So, will he or she will be able to file I-485? Also, if they are in United States, can they do it? And is a valid visa a mandatory prerequisite to file I-485?
They said if they are out of the country, they are inside the country.
I do it outside from US, or do I need to have to be in the country with valid US visa?
Okay, okay. So if you are laid off, from your, current employer, and then you don't have a job and you are already in India, definitely for filing the 485, if you have to adjust, you need to be inside the country. But it can also be consular processed, writing it to the USCIS as the dates are current, and then, triggering the National Visa Center. But it takes time in this scenario, there's no specific form or a specific channel to do that. The attorney on the record, first and foremost, the employer should agree for it, because they should definitely say that we still have that employment opportunity available. Then the next things, second, like attorney writing it to the USCIS, forwarding the file to the NVC, and then once NVC receives it, then they will be getting in touch with the applicant and the employer, and then for the consular process. So it is a little bit difficult to convince the USCIS. I mean, it is possible, but it's time consuming. So, to bring all of these in track, but it would be better if you are inside the country to do that. But I would say, coming here on B2 and those kind of visas, I don't think that works, because it's completely against, the rule of the 485. So,
Thank you. Good luck, Simple Life. Hopefully, this particular advice gives you direction how to proceed. And it's unfortunate that you're in the situation when things become current. Good luck for that. Ravi Kumar Kandle. Here's a question. My priority date is November 2011, EB2. Better to go with downgrade or wait for EB2 or current? Please advise. I'm still with the same employer.
okay, what are the dates he said?
November 2011.
Oh, November. Okay, he's just months away then. I mean, it's up to you. I think, you definitely can see, as, the projections in the visa bulletin, they are projecting the rapid forward movement in the next 2 months. So in the coming months, but, we really don't know. But, definitely, as this is an opportunity for you, I would definitely recommend, if your employer supports you, so downgrade it, and then, try to file the I-140 and 485 concurrently. But let's say, in the next months, if your date becomes current, then you can still have that I-140 in place, and then do another filing based out of that approved one.
Okay, cool. Cool. So you have good options, both options. So wait for it. Or as Janetha has mentioned earlier, and probably time and again multiple times, that she has alluded to the fact how you can apply to downgrading to EB3. Moving on to the next question. I don't know what Gautam is talking about, but he hates to pay money again for I-485, 765, and 131, I-131. But that's a fact of the life, Gautam. I think we'll pass that question. What do you say, Janetha?
Yeah, I mean, without paying the USCIS fees, there is no way that, I mean, the waivers are not applicable in these scenarios. So, yes, of course, that's the reality. So, the fees are, increasing. And then, as you saw, USCIS planned furloughs, in the first week of August, but, somehow, they figured out that they have funds, at least to run it, till end of this year. So unless and until they were in a situation that Congress approves, that kind of funds, they were not able to. But they came up that, okay, we have funds till, end of the year. So yes, the reality is, yes, you do have to pay for the USCIS fees.
Yeah, thank you. Um, Krishna Vamsi has a very good question. I feel like if if I downgrade my processing I-485 or labor from EB2 to EB3, if at all it gets rejected, do I lose my opportunity or priority date on EB2?
It depends upon how the downgrading is done, but definitely, if it is done properly as per the rules, as I'm repeating it again, refiling, it's not amending, it's refiling. So from EB2 to EB3 downgrading, and then refiling the in EB3 category, you will not lose your, EB2 labor. So it will still be in place and not get impacted by the downgrading and then refiling, if it is done properly.
Okay. That's a good question, Krishna. And if you guys have any additional questions on this topic, specific to this topic of downgrading, please reach out to Janetha at Janetha Law Firms. And obviously, after this, we're going to leave her information here. And thank you, Janetha. And we have a few more questions coming our way. If we file 485 based on old employer and I-140, when should we join them back after EAD or after getting GC?
As per the rule, after getting the GC, I would say, because that's when at least I would encourage to work for that employer after having the GC for at least a 6 months time frame. Because what happens when you try to naturalize after 5 years, you have to provide all your employment dates and with whom you are. If they look into that you were never with with the employer whom you got the GC, maybe they might have a flag in there, and then try to contact them or see whether anything fraud, that kind of things are there. Unless and until some companies just go out of business, and then they no longer will have. But at the time of the final adjudication, these days they do have the final interviews, and then they do have that 485J supplement, which you really need to submit again and again when they issue the RFE, when the dates become current as per the final action dates and all. So I would say definitely join them after I mean, if you are willing to in the EAD. If not, mandatorily I would encourage to after having the GC in hand.
Right. Thank you very much. That's a very good question, and I think most of them land into this situation. Naturalization, in the sense here, is to clarify a little bit more, is when you apply for your citizenship after 5 years.
That's correct.
Yeah. Nilesh has a question. That's a question that we have answered. Um, so someone doesn't have a birth certificate, and my parents are unable to get a non-available birth certificate due to COVID. What are the options that they have? Is birth certificate a mandatory thing?
I mean, birth certificate is required to file the 485, definitely. And then if you are not able to get the birth certificate or the non-availability, I would say definitely have your parents do two separate affidavits, one from the mom, one from the dad, saying, whatever the affidavit states. Usually, if somebody is going through our law firm for filing the 485, we do provide a sample of the affidavit, how it should look like. So, go ahead and then get affidavits from your parents. Those should do good, at least for the 485 filing. So, once you do the filing, try to still work on those lines, and then, if possible, try to get it. But affidavit should, do for the 485 filing from both the parents.
Thank you very much. Balaji has similar questions that you have answered earlier. Again, moving from EB2 to EB3 is refiling. You can always move back to EB2 if something goes wrong with EB3, with the caveat that somebody is filing EB3, moving from EB2 EB3, refiling in a proper manner. So if you need additional help or additional questions, please reach out to Janetha after this call or through proper channel with the Janetha Law offices. I think she is more than happy to answer or like help you guys with refiling. That answers Balaji's question, I guess. Do you need to add anything, Janitha, for that?
I think it should be, I mean, nothing additional, but, making sure that, as previously said, make sure you have that kind of conversation with your employer and the lawyer, that, make sure that they are doing, of course, most of the lawyers know what they are doing. So, just have the word with them that, this is what you are doing. So now everybody knows that if they are doing downgrading, it is a refiling and, concurrent filing. So,
Okay, great. Are medicals employer dependent? I don't think so. They are. They are totally a prerequisite for your I-485 filing. That's
yeah,
your
it is the
personal.
individual. Yeah, it's the individual. So you just have to make sure that, go on to the uscis.gov, and then, just in that search bar, just put the doctors. If you, it will, take you to that page. And then if you put your zip code where you are staying, so it will pull up all the, doctors, those who are, covering and, offering those services. So definitely, I mean, you'll be having many in each area, so you can contact one or the other and then get them done, and then it's purely on the employee.
Thank you very much, Janetha. Green card, does it take EB3 takes 6 years to get? What do you think? I think you have already answered. We don't know how long, but don't think. Nobody has a bulletproof answer, a silver bullet to answer this question.
At
Uh,
least now the opportunity is available to file your 485. I mean,
yeah,
you have the year in advance parole, so which is a huge flexibility that you are getting on those lines. So
yeah, you're in a better state from where you are.
that's correct.
So, um, I got promoted from the time my I-140 is filed. Will this cause an issue for I-485 approvals for EB3 category?
See, I mean, of course, as in time move forward, yes, when you are eligible for that kind of escalation in your job, you are qualified, then you will be seeking those. But, as long as the employer says that, green card is a future employment, if they still have that kind of opportunity available for you, you can move forward.
Okay, cool.
Whatever was offered on the labor and then the I-140. So
Yeah. So again, the question is around: do I need to ask to downgrade my EB2 to EB3? Yes, you need to right away. Yes, along with perm I-140 and I-485 filed together. So whenever your I-140 is approved, your 485 eligibility is out there for you. Okay. So I have EB2. This question is from Raghavendra with different role for my current role. Uh, they still have to file permanent I-140 because uh, that's what the question is. So EB2 approved with different role and my current role, they still have, I don't know. So probably it's the same question like earlier one, right?
yeah, I mean,
So
as long
changing
as
roles.
the employers still have that opportunity available for you, they can move forward with that.
Is insurance mandatory for filing I-85?
I don't think so.
Yeah,
Yeah, I don't.
right.
As long as you have medicals, you should be good. I mean, just get the medicals done. I mean, they will be given from the doctor's office in a sealed envelope. So make sure that you are not opening them. So
Oh, okay, cool, cool. So, given the COVID situation, would employment-based green card interviews still applicable or optional?
it all depends. So we are seeing, before March, a lot of interviews, but it all depends upon the USCIS decision. Because if you go back and look into before 2017 October, I mean, the interview section is added after that. So before there were no interviews, your date is current, your card is in production, and then you have the card in mail. But these days, this is an extra scrutiny that they just want to make sure, where the guy is working, whether the opportunity is still available and things like that. But they can still waive it. But right now, I think I mean, they are carefully weighing in on those kind of stuff. But definitely, it's purely the decision of the USCIS. They can either waive it or they can do it.
It's a good question. I think probably we didn't come across when we've been talking about downgrading from EB2 to EB3. Does USCIS ask or to provide the reason why an employee is being downgraded, a priority date, or like a application for immigration is downgraded from EB2 to EB3?
I mean, so far, I mean, I never saw anything on those lines, specifically reasoning, why, but it can be done in different ways. As I said, they will, RFE whether the employer still have the ability to pay, if they are downgrading, and then, y- if the you are not working with that particular employer, then going back, they just want to see whether employer meets that ability to pay. It's not, they don't directly say why, but it can be RFI'd in a different ways. So
Oh, okay. So again, nobody knows if there is a situation. The extreme situation is to that your EB3 application gets rejected. Even in that case, you are still eligible with your EB2. So that is a good theme. That's a good opportunity, I believe. If with additional questions, clarifications, and help, please again reach out to Janetha at any time. So her law office information will be posted after this one. Wamsi has a question. He's off by 18 days for the EB2 date. Is it prudent? Will it be prudent to wait for EB2 or downgrade it to EB3?
I think if it is just 18 days, most likely it will be, you'll be, reaching that in next month's bulletin. As per USCI, I mean, the visa bulletin prediction, that rapid forward movement. So, I mean, you make that call of due diligence and then, see what you want to do. But if it is just 18 days shy, I would say, just wait. But if you cannot, because, I mean, as I-140 cannot be done premium, it cannot be premium processed. So these are all the things you just weigh in the things and then see what you want to. But if it is just 18 days shy, I would definitely recommend you to wait. But if you cannot, if you really want, don't, if you don't, we don't know how it's going to be next month. Maybe if you want to avail that opportunity, go ahead for the EB3 downgrade.
Thank you. Thank you. Uh, Telugu dude. Hey, dude. Here's a question that his wife's prior to date is with EB3 is on 2014 and his is August 2011. So he's wondering should he go with his wife's EB3 and what are the chances that his wife's EB3 final green card will be approved before his or vice versa?
I mean, when you look into the dates, I guess, she's 14, so he's 11. So, she still needs to wait on those lines, much longer. But I would say,
His wife's
for
is
a safe,
EB3, EB3,
E-
EB3
EB3
2014.
for, yeah, so it is, she will be eligible right now. So,
Yeah.
definitely, she can go ahead and file for herself, and then, you can be included as well based on that one, as you will be a derivative beneficiary under the I-140. So both of you can file right now and then wait. Maybe if your dates move forward, the final action dates, better than hers, you can also do on those lines and then the interfile the 485. That's what I would advise.
Cool. What's the approximate attorney fee to file 485 advance parole? Because of this huge rush to file, most of the attorneys are asking filing fee around $5,000. Do you think that this is a standard fee? Or, I mean, you don't have to answer this question, is it? If you're comfortable, then only you can answer this question.
Yeah, it all depends upon how they can manage and then what it is most of the time. So I mean, from our law firm, we have specific fee range for that. So we are charging 1900 for the principal applicant and then 1400 for the wife, and any of the childs as a derivative beneficiary 800 for each child. So I think total bringing up to, if it is for three people, I think two people around 3,300. So, I mean, you can reach out to us at Janetha at janethalaw.com or, legal at janethalaw.com. So our paralegals will be able to provide you with those kind of fee details.
Okay. So again, from Telugu Dude, this is a very complex question. One is like if he go ahead and files EB3 with his wife, and later can he file EB2 when it becomes current again? Can you do that
Yeah,
for
he
the whole
can do
family?
that. Yeah, for the whole family, you can do it. You don't have to file the 485s, saying that because you already have the 485s under the EB3, you can interfile it. Sometimes people don't have patience to wait, for that interfiling because, as I said, there is no specific form or a way to do it. The attorney should communicate back and forth, on those lines to do that interfiling. So most of the time people say, I really don't care about the money, so I'll just go ahead and then file another 485. But there is a way that you can interfile and then not really need to file the 485 again.
Thank you, Janetha. Um, so in the process of downgrading from EB2 to EB3, if EB2 dates get current, will I be stuck downgrading or can I go ahead and file in EB2? Again, interfile is something that Janetha has talked about. You can avail that option. And to get any further help, please reach out to Janetha's law offices. So, um, think we're almost to the end of the questions, Janetha. Um, those um, um, those questions are like more or less like Wamsi's question is about his accreditation. I think you have answered that question. Um, so he has an experience with 18 to 20 months and 4 years patches. Do I need to apply with EB2 or downgrade to EB3?
So yeah, I mean, most of the time, there is couple of universities where USCIS didn't recognize later on, and every time you file the H1B, you get an RFE, and then people really went through a lot of back and forth, and some has to really leave the country. So I would say whoever the attorney you are going with, make sure that you let them know upfront, so that way they'll be able to look into your other credentials and then try to meet you to those credentials.
Right. Your option would be EB3 would be the best option because of your master's accreditation is under question. My Telugu melody, good name. My husband has EB2, but mine is EB3, and priority date becomes current. My husband's H1 extension is in progress. So if I add him during my GC filing, will it impact my husband's H1's extension processing?
Not really. So, I mean, as long as whatever the questions that were asked, on the H1B, they can file the even after the 485 application also, most of the attorneys suggest to have an H1B because, it can help as a fallback status on. So it should not really impact in any way.
Okay, cool. That's great. Um, Simple life. His friend has an EB3 uh, with H1B, but he has to go out of US and come back on L1A. Can he use his EB3 prior to date for EB3 EAD, or he has to only do EB1 again? Continue his EB3 has an EB3 EAD.
I mean, see, as he already filed the, 485 under, the EB3 category, but if he wants to go ahead and, port the date and then, do it under the EB1 as the dates are current, because that will move much more forward than the EB3. So that's a good opportunity to avail, because, you might have your card pretty much, in 8 to 9 months or so, because it's September 1st, 2020. So I would definitely recommend him that, if the company is willing to, and if he qualifies, so it's better he, port the 3 date to EB1 and then do on those lines.
Okay, sure. Thank you. Think we're at the closing time of the hour. Janetha, do you have time to take one more question?
Yes, yes.
Yeah. So my dependence I-94 expired, and its renewal is pending. So with USCIS, can I file I-485 for my dependent?
Yeah, if they are eligible, yes, definitely go ahead and then, file for them, and whatever the I-94s or the extensions that are pending adjudication with the USCIS, just provide them the receipt notices for those. And then I'm assuming that those might be the H4s, and then your H1B might already approved. So provide your H1B employment letter will already be there in the 485, and then the pay stubs and then those kind of things show that you are still maintaining the status. And then as derivative beneficiaries, the H4s are taking time. So yes, absolutely, the receipt notices can go in there, and it will be valid.
Sure, thank you. One question in general is it will it be prudent to maintain H1 while 485 is in process?
It all depends upon the situation. For the flexibility, if people don't want to, maintain the H1B, and then, just want to have the EAD, that's well and fine. But, if at any point of time, something happens to your 485, at least this can be used as, a fallback status, so you can still be inside the country and fight for your case. So most of the time, any attorney you contact, they'll try to say that you definitely, it's, kind of having that, cushion, having a H1B for you. So that fallback status, we definitely would advise. But it all depends upon the individual decision, what they really want to do. Advising something is different from, following. So,
Right.
because people will have different situations, at times they really have to use the EAD. They will not be left with the other options. So that's when they try to. But if you have the opportunity to maintain that fallback H1B status, definitely we would encourage that.
Sure. Yes, there was a question that I think more to do with someone has EB3 prior to date, but she's not working with the employer anymore, and she's on H4 EAD on her husband's H1 140. So, as you mentioned earlier, yes, you can reach out to your old employer and ask them to file I-485, but make sure that you work with the old employer once you get your green card. Green card is always future state, status that your employer is filing on your behalf. Right, Janetha?
Yeah, that's correct.
Yeah. So thanks a lot, Janetha, for all the questions that you have answered here. And to brief up few points, the main and most important thing here is you can always downgrade your EB2 to EB3 filing status. It's a change of filing status, and there are, if in extreme situation, if your EB3 is rejected, you can still fall back on EB2, and it depends on how your lawyer files your EB3 change of filing from EB2. So that is been the critical question so far I heard, and Janetha, thank you very much for your time, and people who have joined from all over the world, thank you very much, and all the best for your future future filing statuses and your plans to get a green card or permanent residency here. However, the most important thing is you need to get a valid and professional advice and help because this is a very time sensitive one and an opportunity once in a decade probably. It happened in 2007 and it's happening again in 2020. Take a proper advice, proper help, and get your situation sorted out and create a plan to move forward. For everything, Janetha is available, and please reach out to her law offices and get consulting and filing and all other immigration helps. Um, Thank you very much, Janetha. Thank you, ABR Productions, and all the best for everybody. And thank you, Janetha. It's been wonderful talking to you. Thanks a lot.
My pleasure.
Have a
Thank
good
you,
evening.
Pawan. And then thanks to ABR Productions. My pleasure.
Thank you.
अपनी एंजेलिना जोली तो इंडिया से आई है, बहुत खुश है। अरे होगी भी क्यों नहीं, अपने पुराने दीवाने मिस्टर अखिल जी से जो मिलके आई होगी। मिलेगी भी क्यों नहीं, बड़ी दीवानी थी उसकी।
दीवानी तो मैं थी यार।
किसकी?
अपने दिल्ली के टेस्टी गुलाब जामुन की।
और हाँ, वो अम्मा जी का टेस्टी फ्रूट कस्टर्ड और वो भरा हुआ क्रंची समोसा। अरे ये टीना कहाँ रह गई? कहीं इंडिया तो नहीं चली गई खाना लेने?
अब इसे ट्राई करो।
ले इन्ना क्रिस्पी समोसा।
मैं ये सब सुविधा ग्रोसरी से लाई हूँ।
सुविधा?
जब देसी ग्रोसरी, ढोकला, समोसा, फ्रेश सब्जी सुविधा ग्रोसरी से मिलती है, तो इंडिया से लाने की क्या जरूरत? क्यों मैडम?
Suvidha International Groceries, the convenience you can trust.